Entonces, vamos a continuar en este seminario sobre tendencias actuales en el derecho de la propiedad intelectual y de la publicidad. Iniciamos el segundo panel de nuestro programa del día de hoy. El panel de ahora es un caso parteaguas. Es el caso Booking.com ante la Suprema Corte de Justicia de los Estados Unidos Americanos. Gerardo Flórez va a ser nuestro moderador. Él es abogado colombiano de Felipe Prieto Carrizosa, Ferrero Du y Uría, ¿lo dije bien? Él es abogado por la Universidad de los Andes. A ver si me escuchan con el ferrocarril, perdón, pero es lo bonito de este sitio. Él es maestro en Derecho de la Propiedad Intelectual por la Universidad George Washington. Es socio principal, como ya dije, en la firma Felipe Prieto Carrizosa, Ferrero Du Anuría. Y su ejercicio profesional se centra en temas de propiedad intelectual. Él cuenta con más de 10 años de experiencia y ha estado a cargo de la práctica emergente de ciencias de la vida de su firma en los últimos 8 años. A él lo acompañan los panelistas David Bernstein, quien estudia en la Universidad de Yale. Él es socio de la firma DeBois Plimpton, en donde dirige el grupo de litigio de propiedad intelectual. Él es uno de los litigantes de propiedad intelectual más prestigiados de Estados Unidos y ha sido también árbitro en diversos procedimientos arbitrales. Él es profesor de la Universidad de Nueva York y de la Universidad de Berkeley. Y Jackie Chorn también nos acompaña. Ella es doctora en psicología por la City University of New York. Ella es directora asociada de NERA Economic Consulting. Ha ejercido como perita experta en un amplio rango de controversias en materia de propiedad intelectual. Ella ha diseñado y ha realizado estudios de mercado en temas relacionados con infracciones de marca, con imagen comercial, con publicidad engañosa, con infracciones de patentes y acciones colectivas. Y ha impartido cursos sobre métodos de investigación y estadística en la Universidad del Pacífico y en el John Jay College of Criminal Justice. Les pido un fuerte aplauso para nuestros panelistas el día de hoy. Adelante, Gerardo, te dejo el uso de la palabra.
Buenos días a todos. Para comenzar, muchísimas gracias a los organizadores. And thank you very much, guys, for sharing the floor. We're gonna talk about a very important case, and we're gonna specifically concentrate on a tool which is very important for us, trademark lawyers and advertising lawyers, which are surveys. So we're gonna go through the booking case first, then we're gonna talk about generism, surveys, secondary meaning, likelihood of confusion, advertising law surveys, guidelines to have reliable surveys, and control sales and stimulus. So, David, please let us know about the booking case, which is a very relevant precedent by the Supreme Court, setting the standard for registering domain names as trademarks.
Well, it's so good to see everyone and to be back in Mexico City, and thank you so much for inviting me to speak with you today. Let me start with a question. Who has heard of the company Booking.com? Okay, the vast majority of you. So let's look at the timeline. For almost 10 years, Booking.com has been trying to register its name and its domain name, Booking.com, as a trademark. You can see that it first applied to register Booking.com back in 2012, so it was 10 years ago. And the United States Patent and Trademark Office refused to grant the registration. The PTO said that because the two parts of the domain name are both generic, the whole domain name is therefore generic. Booking is a generic word for booking travel on a website, and .com is a generic reference for a website. And so when you put booking together with .com, the totality is still generic. And in support of this, the Trademark Office relied on a very old case from 1888 in the United States Supreme Court that involved the trademark Goodyear Rubber Company. Now back then, this is a surprise to me, but Goodyear Rubber was a generic reference for a way to make rubber for tires. And everyone knew that Goodyear Rubber was generic. And also, company is of course a generic term for a business association, for a company. And so the Supreme Court in 1888 ruled that when you combine these two generic phrases, Goodyear Rubber and company, the totality is still generic. And so the Trademark Office said that same principle from 100 years ago applies to domain names. And therefore, booking plus .com is per se generic. Well, booking.com didn't agree. And so they appealed to the courts, and the courts ruled that booking.com can be a trademark. And it went up to the Court of Appeals in 2019, and the Court of Appeals affirmed that and said, yes, we agree booking.com can be a trademark. But the US Patent and Trademark Office was very concerned that this was going to open the floodgates for lots of registration of generic domain names. And so they appealed to the United States Supreme Court. Now, our Supreme Court, unlike yours, takes very, very few cases. They only take 70 cases a year. And they get requests for more than 6,000 cases a year. So it was very surprising that the Supreme Court decided to take this case, and they decided to hear it. And so there was a decision by Justice Ruth Bader Ginsburg ruling in favor of booking.com. It was an 8-1 decision. And if you've read about the political polarization in the United States, you will know that our Supreme Court has many decisions that are split 5-4. It's unusual to get the vast majority, to get a decision of 8-1. And so it was a very strong decision in favor of booking.com. There's an interesting historical twist. This case was heard by the Supreme Court in March of 2020, right at the beginning of the pandemic. And until then, all cases were heard in the courtroom. But we couldn't go into the courtroom because of the pandemic. And so this was the first case in the history of the United States Supreme Court that was argued by telephone. And we were very honored to be on the team representing booking.com in that case. And Justice Ginsburg ruled that you don't look at the component parts of the trademark. You have to look at the trademark as a whole. And the question is, are consumers likely to believe when they hear the entire name, booking.com, that booking.com refers to any website at which you can book travel? Or does it only refer to this one website, this one company? And based on the showing of hands before, I think you all know that it's one company. And so Justice Ginsburg ruled for the court that booking.com can be a trademark. Now, one of the points that she focused on is that survey evidence can be very important in that. And she specifically notes in the decision that because what's important is consumers' perception of the term, whether the term booking.com is understood by consumers as being a brand name, survey evidence is a type of evidence that can be very important in thinking about what the evidence shows of consumers' understanding. And in just a bit, we're going to talk a lot about the survey that was done in the booking.com case and other surveys in the United States for trademark and advertising litigation, because we have a very well-developed legal standard around surveys that are used in litigation, and we see surveys in almost every trademark and advertising case in the United States. Now, I mentioned the decision was 8-1. There was a dissent by Justice Breyer, and Justice Breyer was very concerned that this was going to open the floodgates, as the Trademark Office suggested. He was concerned that there would be lots of people who would try to register things like supermarket.com and lawfirm.com and office.com. And if we allowed this, we would be granting a monopoly to very basic terms. But at the end of the day, his arguments were not persuasive, and the court found 8-1 that there was enough protection in the Lanham Act, our trademark laws, to make sure that when a trademark is registered, it's one where consumers really understand it as a brand name. And Justice Breyer also mentioned the survey. He was concerned that surveys might only be relevant to determine whether consumers have heard of the name before, but they could be misused. And Jackie will talk about some of the issues that come up in surveys and how we can try to prevent them from being misused. Just another one historical little interest. This case was the very last decision that Justice Ginsburg ever wrote. Regrettably, she died that summer. And then, so she's off the court, and Justice Breyer has also retired. So the two main people who wrote this decision are no longer on our Supreme Court. But why don't we turn to the survey that was done in the Booking.com case, and Jackie can talk to us a little about that.
Yeah. So surveys in litigation, we always start off with screening because it's really important that we talk to the appropriate universe. This is kind of one of the reliable criterions for us. And so in this case, it was really important that we were talking to consumers who would actually use a website to book travel. So after the screening questions, we start with what we call a mini course. And this is unique to genericism surveys, but we really do need to teach consumers how to actually respond to this survey. And so we need to teach them the difference between a brand name and a common name. And so we tell them that brand names indicate a company, and that a common name is going to indicate a type of product or service. And we give them some pretty concrete examples. In particular, in this case, it was really important that we give a .com as an example of both a brand, so staples.com, and as a common name, officesupplies.com, to illustrate for respondents that .coms can serve as both a brand name and a generic name. We then ask respondents, does this characterization, this exercise that you're being asked to do make sense? But we don't just take their words for it. We give them what we call a mini test. Afterwards, we showed them two terms, and we asked them to characterize these as either a brand name or a common name. Only respondents who were able to correctly characterize Kellogg as a brand name and cereal as a common name were allowed to proceed to the main questionnaire. So in the main questionnaire, genericism surveys typically test anywhere between about 8 to 10 terms. And we test these individually and in a randomized fashion, so to try to prevent order effects. The one of interest in this case, obviously, is Booking.com and whether or not consumers perceive this to be a brand name, a common name, and we always provide an option for them to indicate that they don't know. So when doing these types of surveys, what we really want to see is, like the threshold requirement that we're really looking at, is anything above 50% is generally considered, 50% of respondents indicating that a term is a brand name is considered probative that this functions as a brand. And as you can see on this slide here, which presents the results for Booking.com, nearly 75% of people indicated that Booking.com was a brand, which is clearly above that majority threshold that was required.
And David, are there other ways to use these surveys to assess whether the term is generic?
There are. So the survey that Jackie just described is something we call a Teflon survey in the United States. And that's because that format of a survey was developed in a case many years ago about the question of whether the word Teflon is a generic term or is a trademark. And so before that case, we didn't really have a survey to test that question. And in that case, the expert came up with this idea, and the court said, yes, that's a good idea, this one works. And so lawyers were very conservative. Once a judge tells us, yes, that's a good survey, lawyers like to use the same survey over and over again. But there was another case that raised the question of whether the term thermos, let's go back just to this thermos one, to whether the term thermos can be a trademark. And the expert in that case said, I'm going to flip it. Instead of asking people, do you think thermos is a brand name or a common name, I'm going to describe what a thermos is. I'm going to say there's this thing that holds beverages. It's an insulated container. and it will keep hot beverages hot, and it will keep cold beverages cold. What do you call that? And so this is a way of seeing what do consumers on their own come up with to tell us, do they think, what is the generic term for that? And in that case, a lot of people said, I think the generic term for that kind of a container is a thermos. And so that was found by the court to be proof that thermos is a generic term. So these thermos surveys are also an accepted method. I will say they're not done as often, but I think they're a better way of understanding what consumers' top-of-mind thoughts are. And we're doing this in a case that we have against the Trademark Office right now. We represent the company Snap, which makes Snapchat. If you don't know about Snapchat, your children probably do. It's a very popular social media website in the United States. And they have these incredible glasses that you wear, and they've called them spectacles. And inside the glasses is a little mini camera, and when you press a button, the camera records what you see and posts it onto your Snapchat. And so Snap tried to register the brand name Spectacles for these cameras that are inside the glasses, and the Trademark Office said, no, that's a generic word. So we've done a thermos survey where we asked people, what would you call eyeglasses that can connect to your phone and can record video and audio? And the vast majority of people said smart glasses or smart eyeglasses. And so I think that tells us that's what the generic term is. Only about 1 or 2% said spectacles. And so that shows us that very few people think spectacles is a brand name. And since Jackie mentioned that you need 50% to show it's generic, we're going to submit this to the court to show that this is strong evidence that spectacles is not a generic term.
And David, so if the term is not generic, is that the end of the analysis, or can anything else be done?
Yeah, so that only gets to the first question of whether it's generic. To register it as a trademark, to protect it, we still need to show that if the word is descriptive, that it has secondary meaning. And so we do have secondary meaning surveys in the United States. And here the question is, do consumers understand a descriptive term is merely descriptive, or that it's acquired distinctiveness? And I'll give you an example. If we think about the phrase European airlines, there's lots of European airlines. It describes KLM, it describes Lufthansa, it describes British Airways. And so European Airlines is not a trademark, it's merely descriptive. But if I say American Airlines, people immediately know that I'm not talking about Delta or Southwest or United, I'm only talking about the company called American Airlines. And so the question is, are things called American Airlines associated with one company or more than one company? And we did a survey like that when we were helping our client register the trademark vitamin water. It is a descriptive term. It describes water that contains added vitamins. And so we do this survey where we ask people, do you associate Gatorade with beverages from one company or more than one company? And obviously, everyone says one company. Do you associate iced tea with beverages from one company or more than one company? There, people say, oh, there's lots of companies that make iced tea. It's a descriptive term for many beverages. And then we ask about vitamin water, and 55% said, I associate vitamin water with just one company, and the Trademark Office accepted that as evidence that vitamin water can serve as a trademark and in fact is understood by consumers as being a trademark.
And then again, since there's a lot of trademark lawyers and advertising lawyers, we all know that surveys also serve to prove confusion. How do those work?
So these surveys are done more in litigation than in the Trademark Office. And the question now is, are consumers likely to be confused? So I'll tell you about the facts of this case, and then Jackie can tell you about the survey. Our client was Kraft, and Kraft had a relationship with Dr. Arthur Agatston, who wrote the very famous book, The South Beach Diet. That was a book that taught people if you eat a low-carb diet, that's a good way to lose weight. It hasn't worked for me, but maybe it's because I like tortillas too much. And so Kraft was going to come out with a line of food products that would be called the South Beach Diet, and would be food products that consumers could eat if they want to follow this diet. And while Kraft was planning that, someone else launched these bars that you see. This is a meal replacement bar, and you can see they called it South Beach Solutions. So we brought this lawsuit, and we needed to think about what kind of a survey can we do to prove that consumers who see South Beach Solutions in the marketplace will be confused into thinking that it comes from the South Beach diet.
So it comes to how do you test confusion?
Right. So in these types of cases, we have a couple formats that the courts have accepted as reliable. One format that we use, especially when Mark has a top-of-mind awareness, is called an ever-ready survey. And the questions here are on the screen. I know that's a lot of text, but it really goes down to the questions of confusion that are set forth in the Lanham Act as to what is relevant. And so, we want to know when people see the junior user or the allegedly infringing product, South Beach Solutions bars, do they think of the senior user? And we get at this with a line of open-ended questions, and respondents need to indicate in response to one of these open ends that they're thinking of South Beach Diet for them to be counted as confused. And the line of questions we ask about, who makes or puts this out? Do they make or put out any other products? Are they connected or affiliated with any other companies? And sometimes we ask about whether they received permission or approval to put this product out. As is typical, we often ask a follow-up probe afterwards to indicate why do you say that, which sometimes helps us understand where that confusion is coming from. And so in this particular survey, when respondents saw the bar, the South Beach Solutions bar, we saw that nearly 25% of respondents indicated that the South Beach Solutions bar had a relationship or came from the South Beach Diet trademark. And so this is what is typically considered to be above the levels that would be considered probative of likelihood of confusion. And what you can see on the screen here with the bullet pointed lists are responses to some of the open ends that indicates what was driving consumer confusion. And you can see that it was really driven by the name South Beach and the bar. And we've been kind of hitting on this point throughout the talk today about kind of what thresholds are required. As a survey expert, we never like to go on record with what's exactly required, but I would say I feel pretty confident that I'll be asked to write an expert report if it's above about 15%. Anything that's in the range of about 10 to 15%, I would say is a little bit questionable. It could depend on whether the expert's on record for saying that numbers that are below that are not probative of likelihood of confusion, although most experts, again, try to avoid going on record as it gets to like ultimate opinion testimony. But it could also depend on the other factors in the case as to whether there's other factors that would demonstrate that there is likely to be a likelihood of confusion. But when we see results that are below 10%, it's a pretty much a guarantee that we can stop that survey and not proceed with it.
Yeah, and so we can flip this around, and surveys also can be used to show that there's no confusion. So since we're in Mexico, I thought I would talk about a tequila case. This is a case we have in Texas right now. And I'm sure many of you recognize the bottle of tequila. It's Clase Azul, which is a very well-known tequila. And our client makes the tequila canned soda Casa Azul. And so the folks who make Clase Azul have sued for trademark infringement. So we did a survey, and we asked the same kind of questions, the same ever-ready questions that Jackie just described, asking people, who do you think makes Casa Azul? What other products do they put out? Do they have a relationship with anybody else? And the results were very strong for us. As you can see from the chart on the next slide, the vast majority of people recognized that it's Casa Azul. That, after all, is the name of the product. Only less than 1% said that they thought it came from or was associated with clase azul. And so we submitted this evidence to the court, and the court found that this was very strong evidence to show that confusion is not likely, and therefore the court denied the motion for a preliminary injunction.
Okay, and Jackie, please let us know a little bit more on advertising surveys. How do those work?
Yeah, so when it comes to advertising surveys, we really have a couple different types. One type that we get that often aren't tied to litigation, so they can be kind of just fun to actually conduct, are for claim substantiation. When an advertiser wants to make a claim about consumer preference in an advertisement, they could reach out to see whether they have enough data or reliable data to be able to substantiate that claim. So claim substantiation surveys are really seeking to understand whether or not there's a reasonable basis to make that claim. We've talked some about thresholds today. In the Teflon survey that we talked about, we're looking at gross numbers. In the likelihood of confusion, we're looking at net numbers. So we take what's in the test and we subtract the control. But when we're talking about these particular surveys, we actually have to use statistics and prove this at above a 95% level for us to confidently make the claim that they have a reasonable basis for making this type of claim. So in this advertisement that we'll show now, we were looking to see whether, I don't know, actually, is it going to play?
I don't think we have the sound, but I'll tell you what it says. It says here in Texas we have really big bugs. And so we need something that's going to keep the bugs off. And Off-Skin-tastic is great for bugs, and it feels great on your skin. And then later it says, the bugs are as big as hogs here in Texas. They're so big. But it said 4 out of 5 Avon users prefer the feel of Off-Skin-tastic. And so the question would be, how would you prove that 4 out of 5 Avon users prefer the feel of Off-Skin-tastic so that you could make that claim in an advertisement? So we also use surveys in advertising litigation in the United States to communicate what consumers understand. And that can be a very big issue because judges aren't experts in what an advertisement means. So this was a case we had for a heartburn product. The product was called Mylanta Nighttime Strength. And if any of you have suffered from heartburn, you might know that it's worse at night because you might have eaten a big spicy meal, then you're lying down, it's easy for the acid in your stomach to reflux up into your esophagus, which is what caused that burning sensation. So Mylanta came out with Nighttime Strength, and we thought the suggestion was that this was going to last all night long. But in fact, this is just an antacid. Once you take it, it will solve your heartburn, but it only lasts for 20 minutes. And so if you're trying to fall asleep and your heartburn goes away for 20 minutes and then it comes back, that's not going to help. You're going to wake up again with heartburn. So we sued, saying the name of the product was false advertising. And we did a survey where we asked people, what are the main messages communicated by this? Does this label tell you anything about how long it will last? What does it tell you? And we found that over 25% of the people said, I think this product will last all night long. And because that wasn't true, the court entered an injunction against this. The case went up on appeal to the Court of Appeals, and the Court of Appeals affirmed that. And so this is actually a very important precedent in the United States, standing for the proposition that even a product name can be false advertising, and the survey was a critically important way of trying to prove that.
And then it becomes of the utmost importance to have reliable surveys. How do you tailor that?
Yeah, so surveys for litigation have to adhere to really rigorous standards. That's unlike traditional market research. Survey experts like myself, we follow some treaties that have been written, such as the Manual for Complex for Litigation and the survey chapter on the reference guide for survey research. And in general, I would say, what's listed on the screen is what we are trying to adhere to. The most important things, and where we often see critiques, have to do with the definition of the universe. So we have to define who the relevant consumers are. And we're not obviously going to talk to every single consumer that's part of that universe, so we need to develop a sampling plan that ensures that our sample is representative of that universe. That could mean that we need to set age quotas or gender quotas. Potentially it could be something that skews in a particular geography. So we have to consider all of those types of things. And then the next part is ensuring that we write a questionnaire. As we've talked, like the Ever-Ready survey format has a standard format that we need to follow. And so, when that's the case, we follow the accepted guidelines. But other times, like the false advertising survey that David just spoke on, those are a little bit more unique, and we really have to tailor those survey questions to the particular case. We also have to ensure that we use consumer-friendly language. I will say that sometimes when we're doing surveys for the USPTO or the TTAB, this can be a real challenge because we're tied to the registrations, and the registrations are not necessarily how consumers think about products or the description of products. And so, there's sometimes a conflict between ensuring that it's going to be something that the legal body is going to like, and also ensuring that consumers understand what we're talking about. Additionally, trying not to introduce any bias into the survey. So a lot of things go into the survey design. And then there's the part about selecting a stimulus. And this can be a hotly contested issue as to what stimulus you pick. If it's a product, do you test the website, or do you test the product that's sold in stores? If it's an advertisement, was it displayed in all DMAs, or how long did the advertisement run? Basically, how many consumers could have been deceived by an advertisement? These are all things that we have to consider when weighing what type of stimulus we're going to pick. And then we need to design a control cell, and this is where we really get into the nitty-gritty of survey design. Designing a control cell is, I've heard it described as an art, not a science, but it's a little bit of both. So we have two groups of respondents, and the control group, we want to not be exposed to the allegedly infringing element, but we have to figure out how we're going to isolate that. And then we also have to analyze our data with accepted statistical principles. And sometimes this gets really tricky, especially when we talk about coding of open ends.
Jackie, and what are the most common criticisms and attacks that you get to have against surveys, and how to fend them off?
Yeah, that's a really good question. I think a lot of the topics that I've already covered are really the issues that we get critiques on. People really do go after our universe, our control, whether we picked the right stimulus. I see a lot of critiques that our universe is over-inclusive or under-inclusive, that our sample isn't representative of those that we said we intended to target, that we picked a control or we picked a stimulus that nobody was going to see. Whether these critiques actually have any sticking power or validity behind them, I think goes into one, what type of survey it was. But the second part of that is, could they run a survey and demonstrate? So a really powerful critique is one that fixes those elements. If you had run the survey with a different universe, if you had run it with a different stimulus, or if you had modified the control in a different way, would you have seen different results? And those are the types of critiques that are really powerful and have a chance to kind of discredit some of the credibility that's associated with that. But in US litigation, there's almost always an opposing expert on the other side, so there's no perfect survey. And then, so I've hit on this topic of controls, and this is such an important topic when we think about how to design a good survey that I wanted to spend a little additional time talking about it. And the analogy that I think always makes the most sense, if you're not a scientist, is to think about these like clinical trials. So in a clinical trial, you know that there's one group of people who they're assigned to the test or the treatment, and they get the active drug. And then there's another group of people who are assigned to the control, and they get a placebo. And the researchers in these types of clinical trials try to hold everything constant between these groups. They ensure that the pills that the people are taking are the same color. They ensure that they follow the same protocol, that they have to come into the clinic equal number of times to be measured. They use the same type of dependent measures. They ask them the same questions. So everything between these are held constant. And because of that, when there is a difference between the people who participated in the test group and the control group, you know that that difference is due to the active drug. And in surveys, we do the exact same thing. We have two groups of respondents, and we try to do the exact same thing, where we identify whatever is claimed to be allegedly infringing or allegedly deceptive, and we try to isolate that element. And so one way to think about it is that our control group really serves as kind of the baseline. Actually, do you mind going back for just one second? So those factors that are on this slide, the guessing, the preconceived beliefs, market share, these are all going to show up in our control cell. And that really provides the baseline of what we would expect to find without the alleged deceptive or infringing element. And then our test group, if there's any difference between those groups, we now know that we can attribute that to the allegedly infringing element or the deceptive element. And so, just to kind of hit this one more time, but this is the quote that I will say David can probably attest. We put in almost every single one of our expert reports. This is really the key issue, is how to isolate those elements that we truly want to understand. So we want to control for everything but for the issue that we hope to understand. And in the drug trial example, that's pretty easy. They either get the active drug or they do not. But when it comes to surveys for litigation, the control is where there's just a ton of debate as to whether or not we did it correctly.
So let me show you an example of how that works so that you can see the issues that we focus on when we're designing these controls. This was a case that we handled for Novartis, which makes X-Lax. And X-Lax was removed from the market because the FDA found that there was a problem with the active ingredient. And so it was relaunched with a new active ingredient made from the senna plant. This is a natural laxative, essentially. And you can see, to make the packaging look different so that consumers would know that this was not the old X-Lax that had been removed, it shows a picture of the plant and it says new natural formula, natural senna formula. And in this case, one of our competitors, Schering-Plough, which makes the product Correctol, sued for false advertising. And they did a survey where they showed people the X-Lax, and they said, do you think this product is all natural, or do you think this product is not all natural? And they got 51% of people saying, oh, I think it's all natural. But we didn't believe that. We thought that they were just getting people who were guessing, because if you ask people, do you think it's A or B, and you have no idea, you'll guess A or B. Actually, the fact that half of the people said all natural kind of suggested to me they were just guessing. Or do you have a preconceived notion that all laxatives are all natural? Or was there some bias in the way the questions were asked? We thought that they should have done a control cell. And we're giving an example here where you could cover up the word natural. So I don't know if you can see it. Maybe if we just put the arrows on, you'll see I can show you where that's at. If you just click ahead again. Yeah, there you go. So if you covered up the word natural and you asked a group of people the same questions, if you showed them the product this way and said, do you think this product is all natural or it's not all natural? The word natural isn't there anymore. And still, you might get half of the people guessing, oh, all natural. And so that would be strong evidence that it wasn't the use of the word natural on the product that was causing the confusion. It was just that people were guessing, or that people had a preconceived notion. In this case, they didn't do a control cell, and so the judge threw out their survey, and she denied the motion for preliminary injunction. And the same thing is used in trademark cases. So just our last slide, going back to the South Beach case that we talked about before. Here, we showed one group of people South Beach Solutions. That was the test cell in the clinical trial, the way that Jackie described it. And we asked, who do you think makes this, and what other products do they make? And we got 25% saying, oh, I think it comes from the South Beach diet. And then in the control cell, we held everything the same, but we removed the word South Beach. So it was still a bar, it still said solutions, It still was in that light blue color. It still had the palm trees that you see in South Beach, Miami. It still said this is for the low-carb way of life. So it still had all of those elements on it. And when we asked the people in the control cell, who do you think makes this, we only got 1 or 2% of the people who mentioned the South Beach and the South Beach diet. And so that was very strong evidence that it was the use of the word South Beach on the product that was causing the confusion, and this supported our claim for an injunction. I know that there was a lot of detail on these slides, and also that surveys are a little bit newer here in Latin America. If you're interested in getting a copy of the slides, you can give me your card. I'll be happy to send you the slides. I also can send you a chapter that we wrote about a lot of the mechanics on how to do surveys, if that's something that interests you.
Okay, guys, thank you very much. Yes.
In Mexico, surveys are done in different big cities. In the United States, you have to do it just in New York. For example, in the case of the net circuit, you just do it in California, or you have to do it all over the country.
Yeah, that's a good question. So it really depends on the case. For class actions, we often do only care about where the class is trying to be certified, and so we will try to target maybe like California or New York, for example. But in general, I would say, if it's an advertisement, for example, that is applicable to the entire United States, then we would try to survey, a representative group of consumers from the full U.S.
And when I was a young lawyer and had hair like Jose does, we used to do surveys in shopping malls. So we would go into the shopping mall. In this South Beach case, this was 2004. So we actually made these bars. We made the packaging for the control cell, and then we shipped the products to malls all around the country. And people were interviewed in the malls. But today, the vast majority of surveys that we do are done online. And indeed, in the Booking.com example, those screenshots we showed you were from the actual online survey. So it allows us to really target in a much better way, where do we want those online surveys to show. And we work with a lot of different vendors who will provide us with email addresses. But we can tell them, we want to get the email addresses of people to invite in our survey who live only in the Pacific Northwest and whose income is more than $100,000, or they have children. Whatever the universe is, we can actually help to target who we're trying to get at with these online surveys. And it's much more efficient and less expensive than the way we used to do it in the malls.
That's why you have to specify the questions so you can obviously obtain the results you want.
That's right. Jose said that's why you have to really specify the questions to know what results you're looking for. Are there other questions? Okay, well, thank you all very, very much. Oh, wait, there is one back here.
I have a microphone, yes, so because it's being streamed.
So I have two questions. How do you get the respondents involved? Do they get paid, or are these just people that want to help, or?
Yeah, no, they don't just want to help. They're generally part of what we partner with several firms. In fact, many of these are international, so they would have a group of people who have agreed to be contacted for surveys, and they receive a small monetary incentive for doing so. In general, I would say most of their surveys, they probably earn about 50 cents, and so they'll do multiple surveys, and they can compile these for later gift cards that they use. The other way that we occasionally will go with, getting respondents is through a list from our clients, but I will be honest, when people haven't agreed to be contacted and you have a random market research firm reaching out to you, I'm sure you've all received those emails, you delete them. So we have a pretty low response rate when it comes to that.
Okay, and thank you. And the second question is that if the result is not favorable for you, in the context of a litigation, do you have to disclose the result, or you can make a different survey?
So I'll take that one. This gets to the question of privilege. And so in the United States, we have a very strong tradition of what's known as the attorney work product privilege, that my work as a lawyer isn't discovered by the other side. So in order to try to protect the surveys that don't come out well, I will hire the survey expert. I will direct the survey expert. Indeed, we work with Jackie and her colleagues quite a lot, and they'll report back to me. And that will help me think about my strategy for the case. If the results are not good, I can claim that that's my attorney work product, and we don't have to disclose it. But that often means that I won't share it with my client. Because if I tell my client, and they share it with the marketing team, and the marketing team relies on those surveys for other reasons, it could lose the privilege. So we can, if we structure it well in a litigation in the United States, we can take steps to protect a bad survey from being disclosed. Very often, especially in a big case, we'll work with 2 experts. We'll have one expert who we call a consulting expert, who only consults with me, and might go out and do a bunch of small pilot surveys to help us see how would the survey be most effective. And then once we have a good idea of how it's going to work, then I call Jackie. I don't let her know that I've done these pilot surveys, but she's very smart and sophisticated. She knows that I've done that. And we talk about the survey, and she says, I'm thinking of doing it this way or that way. I say, oh, I really like this way better. Now, I don't tell her what the results of my pilot survey were, but she might realize I have a reason for wanting to do it that way. And so that way we can protect the work we did with the consulting expert, but the testifying expert would only talk about the survey that she did.
Thank you very much.
Bueno, agradecemos a Gerardo, a David y a Jackie por esta exposición tan completa, tan útil para todos.
I have another question.
Perdón, hay otra pregunta.
Thank you. I have another question. In Mexico, we have recently adopted the secondary meaning in our new federal law. And I wonder what kind of evidence do you, in America, usually use for proof secondary meaning? Because I know that it is very important, the survey, but what other evidence is used to?
Yes. So there's a lot of other type of evidence beyond surveys that we can point to. And indeed, in many cases of secondary meaning, you don't need a survey. So you could show what were your sales? How much advertising do you do? Is there market recognition? Have you done a brand awareness study that shows that your brand is well known? Does the media talk about it? If you're talking about meal replacement bars, for example, does the media say, you know, if you're interested in losing weight, you can eat Cliff bars and Kind bars and South Beach diet bars? And so we would look at how do consumers understand it. Today we look at social media a lot. What do consumers say in their posts? Do people use capital letters? Do they reference the brand names? We can look at also that when the consumer writes back to the company. So it's that whole range of products, of evidence. If that evidence is all very good, you might not need a survey at all. You might be able just to rely on that evidence. I would say that in the trademark office, most of the time, you would submit non-survey evidence in the first instance to try to persuade the trademark office that your trademark has secondary meaning. But if they refuse it the second time, that's when we typically would think about a survey, which I like to think of as kind of icing on the cake. You've already baked the cake, but now we're going to give you a little bit more evidence that it really does have secondary meaning.
¿Hay alguna otra pregunta? ¿No? Muy bien. Pues
Thank
ahora
you all
sí,
very,
muchas
very
gracias.
much.
Thank you.